This is LXBN TV, and I'm Colin O'Keefe. Earlier this week, the Supreme Court ruled on Arizona's controversial immigration law, the Support Our Law Enforcement and Safe Neighborhoods Act, tossing out some elements of the law while upholding what may be the most controversial part of the law. To explain what's in, what's out, and what it means for other states, we bring in Daniel Burnick, partner with Sirote Permutt and author on the Alabama Employment Law Report. Daniel, let's start with what the Supreme Court struck down. What provisions of Arizona's law did the Supreme Court determine were either unlawful or unnecessary?
Well, the Supreme Court struck down three provisions of the Arizona law. The first provision is Section 3, which makes it a criminal misdemeanor for the, quote, willful failure to complete or carry an alien registration card, end quote. The court in that case found that Congress has occupied the field of alien registration, and therefore it was preempted by federal law and struck that down as being unenforceable at the state level. The Supreme Court also struck down Section 5C, which interestingly has no federal counterpart. 5C of the Arizona law makes it a criminal misdemeanor for an authorized alien to knowingly apply for work, solicit work in a public place, or perform work as an employee or independent contractor. What the Supreme Court found was, under the Immigration Reform and Control Act, IRCA, that Congress had addressed criminal penalties for employers for improperly employing unauthorized aliens, and only made it a civil penalty for the employees themselves if they were unauthorized. And the court found that since Congress made a deliberate decision not to make it criminal for an unauthorized employee to seek work, therefore it was preempted by that congressional intent. The third section that the Supreme Court struck down deals with state and law enforcement officers, and what the Arizona law says is that a law enforcement officer can, without a warrant, arrest a person if the officer has probable cause to believe that the person has committed any public offense that would make him removable from the United States. And because there is no counterpart to that, the Supreme Court found that this in fact gave state law enforcement officers more authority than federal law enforcement officers have, and therefore they found that it would be preempted by the federal law. Interestingly, the federal law provides that an alien who is suspected of being removable is issued a notice, which is a civil violation, a notice of removal, and if they appear and they get deported or not get deported, that's fine. But if there's a notice of removal and they don't appear, then at that point in time they could issue a warrant at the federal level to have that person arrested, or they may keep them in detention under certain circumstances if they suspect the person may leave or not show up for their hearing. And this is where probably one of the most debated comments by Justice Kennedy was written, where he says, quote, as a general rule, it is not a crime for a removable alien to remain present in the United States, end quote. And those are the three areas that were struck down by the Supreme Court. What was kept in place by the Supreme Court in an 8-0 vote, so it was unanimous on this particular provision of the law. Section 2B requires state law enforcement officers to make a reasonable attempt to determine the immigration status of any person they stop, detain, or arrest on some other legitimate basis if reasonable suspicion exists that the person is an alien and is unlawfully present in the United States. And the court gave two examples of when it may or may not apply. The first example was jaywalking. If somebody jaywalks, they get a citation and they're set free. The court basically said in that situation, it is not reasonable to detain a person to check their immigration status. However, if you have a DUI and you're actually arrested and you're taken to jail, then at that point in time, the state officials can check the immigration status as long as it does not unreasonably increase the amount of time that detention normally would have taken. The court found three safeguards there: that a person is presumed not to be an illegal alien, that they may not consider race, color, or national origin in making an arrest or checking on the status of their immigration status, and it must be implemented in a manner consistent with federal law. So that's the part that is in place. And interestingly, the Supreme Court said that since the law was stayed by an injunction prior to it being implemented, they really have nothing to look at. I have heard that there are groups lined up ready to start filing lawsuits alleging discrimination under this particular provision once it is enforced.
And I think, yeah, I mean, that was the part, it's my understanding that that was the most controversial part of Arizona's immigration law, and that's what the Supreme Court ended up kind of leaving in place, leaving as is. Why did the court leave that as is? It was my understanding that, based on some of the things you talked about, that there were certain elements that were okay, but it doesn't prohibit future immigration or future litigation from taking place based on that law, but the law as it exists is okay by the Supreme Court. Is that about how things stand now?
That's about how things stand now. That section is enforceable. It's in place. And what I suspect is going to happen is you're going to have cases where you're going to have allegations of a disproportionate number of Hispanics or Asians are being arrested on false charges just to check immigration status.
I saw that just as I was actually looking up research just for this interview. Since the court ruling had been filed, that already been stepping up enforcement under this law, even though it's just the ruling that came down. So it's going to be interesting to watch. And then, of course, it doesn't just have an impact on what's going on in Arizona, but also in other states as well. So what does this ruling mean for other states with stricter immigration laws, like Alabama, for example?
Well, I think it's clear that if a state has an immigration law that contains the three provisions that were struck down, Alabama has two of those provisions, I think it's pretty clear that they're not going to be enforceable, and the states are probably better off not enforcing or trying to enforce those particular laws. The Supreme Court has spoken. That's the rule of the land, and that's the way it is, whether you like it or not. I suspect, just as in Arizona, under the part that is still in place where an officer can make a reasonable attempt to determine immigration status, you're going to be seeing a number of lawsuits filed in those states, Alabama, South Carolina, Arizona, as people are arrested, as immigration status is checked. Either people who are actually legally here alleging they're being profiled, or perhaps even people who are unlawfully here, again alleging they were stopped solely for racial profiling. And that's going to be a factor of how many Hispanics are arrested, how many Asians are arrested compared to the general population. Are they being targeted? Are roadblocks being set up in Hispanic neighborhoods as opposed to in just general neighborhoods?
Yeah, I'm really interested to watch that going forward and see. I mean, we get a sense already of what impact this is going to have on the other states' laws, but I think the reverberations from what's left in place is going to be very interesting to watch going forward, and what's going on in Arizona. Well, once again, that was Daniel Burnick of Sirote Permutt. For more of his commentary on the ruling, be sure to visit his publication. It's at alabamaemploymentlawblog.com. And for more coverage of the ruling from LXBN, be sure to check out the immigration channel at lxbn.lexblog.com. Thanks, Daniel.
Thank you, Colin. I appreciate it.